Officer, I would like to thank you for your assistance. If you would please position Mr. McMorris under the microphone, please. Sir, can I please get you to state your full name and your date of birth for the court, please, sir?
Mantavious McMorris, 3rd, 23rd, 81.
Thank you, Mr. McMorris. I'd like to say hello to you this morning. We're here for a simple bond court arraignment. Today's date is Wednesday, June the 16th, 2021. The exact time is 9:46 a.m. Once again, we're here for a simple bond court arraignment. I'm not here to try you in any way on whether or not you're innocent or guilty. I'm just here to inform you of your charges, your bond amounts, and your rights. You do have the right to remain silent. You have a right to a trial by jury. You have a right to have an attorney present. If you cannot afford one may be appointed to you by our public defender's office. For the charges that are being presented to you today, for any reason they are dismissed, discharged, no pros, meaning not prosecuted, or you're found not guilty, they can and will be expunged from off of your record. When and if you are released from this court, you will have a court date or court dates that will demand your appearance. It is very important that you're in court the day and time that you're supposed to be there. Do you understand? If you're not there, you will be tried in your absence and issued a bench warrant for your arrest. We're very serious about you being in court the day and time that you're supposed to be there, to the point that we will provide you with the name of the court, the address of the court, and the telephone number of the court. Do you understand?
Yes, ma'am.
If you are not there, because your charges are all general sessions in nature, if you're not there, you will and can be fined up to $5,000, incarcerated up to 5 years and above. For the one magistrate level charge that you do have, if you do not show up at court on that charge, you can be fined up to $1,000, incarcerated up to a year and above. Because you do have general session charges, you will have that right to what we call a preliminary hearing. This is what the preliminary hearing form looks like. What a preliminary hearing is that you'll go before another judge, and the law enforcement officer that took the charges out against you will be there to present the evidence on the behalf of the state. Your attorney will be there to present your evidence. Once that judge has heard all of the evidence from both sides, he or she will determine whether or not your charges will go to another court proceeding or whether or not they are dismissed. So, Mr. McMorris, if you wish to exercise this right, what you will do is fill out this information here. You can give it back to me. I'll be more than happy to extradite it for you. If you choose not to give it back to me, you must mail it to the address provided within 10 days. If you don't do so within 10 days, you will lose that right. If or when you are released, you will have a condition of bond. You must follow through on that condition of bond. You understand, if you do not follow through on that condition of bond, you will violate that condition with the possibility of being at risk of being reincarcerated as well as additional criminal charges. So you must follow through on those conditions, which I will instruct you on those a little later. All right. For the charges that are to be presented today, driving under suspension, third or above offense, as well as reckless homicide, hit and run, resulting in a death, habitual offender, causing death. At this time, we have the family members of the deceased, Ms. Carly Brewer-Sutcliffe. We have a family member that is going to be the spokesperson for Ms. Carly Brewer-Sutcliffe. And before I begin, I'm going to give some instructions to Ms. Vanderbroer Ice. I do understand that you're going to be the one speaking for the family today. Is that correct? Okay, if I can please get you to have a stand. And before I even begin to say anything any further, I want to offer my condolences to the family. Okay? Now, going forward, Ms. Vanderbroer Ice, there is a protocol because you are being the spokesperson of the family. You have the right to speak on the family's behalf. You will not be censored in any way. Whatever it is you want the court to know and to understand, you have free reign in saying so. Once you're finished speaking, Ms. Ice, I will come back to you, Mr. McMorris. By you being the defendant, you have the right to respond to what Ms. Ice has stated. You have the right that you don't have to respond. That's completely up to you if you choose not to respond. Please keep in mind, you will not be censored as well. You will have one say, sir. And then once you're finished speaking, I will come back to you, Ms. Ice, and then we will have the last say with you. Okay? Please proceed.
Thank you, Your Honor, for the opportunity to speak on behalf of my precious daughter, Carmen.
Ms. Ice, excuse me for one moment. Can you please get up close to the microphone and project your voice as much as you can?
Sure. Yes, please, Your Honor. Thank you, Your Honor, for this opportunity to speak on behalf of my precious daughter, Carmen, who was killed during a peaceful bike ride with her husband on a beautiful Sunday afternoon. I speak on behalf of all of Carly's loved ones today, including her husband, Ryan. Ryan cannot be here because he is currently receiving inpatient medical care. As you can imagine, the trauma and shock he experienced when he discovered his new bride lying dead on Sulphur Springs Road is more than any person should ever bear. The horror of the scene was exacerbated by Mr. McMorris's cowardice when he abandoned Carly and left witnesses to show her care in her final moments. Carly and Ryan loved Greenville. They were married here in November and made their home here. They loved biking the Swamp Rabbit Trail and spending time outdoors with family and friends. And in one split second, all of that was torn away as Carly began to do something so simple as use the crosswalk on the trail. In that moment, Mr. McMorris took Ryan's everything. Ryan's husband, they're destroyed by that moment. I was my precious daughter, happy, loving sister to her brother and sisters. She was their biggest advocate, supporter, and encourager no matter what life threw at them. When her father died just 2 months ago, Carly was the glue that held her siblings together during their time of unimaginable grief. And now,
Mr. McMorris, is there anything you would like to say in response to that? You don't have to say anything in response. You can speak on your own behalf or whatever it is you would like the court to understand. You have free reign.
I'm sorry for y'all guys lost, man. At the time of this date, man, I was not driving this truck. My truck got stole open Sunday morning. So I do not have a clue who was driving this truck when this accident happened. But for y'all to keep bashing my name like that, man, I mean, I have not done anything. I have not done anything to anyone. If I would have hit this lady, I would have stopped her. I mean, I wouldn't have did that. I'd have been hit on a motorcycle recently. I would not have hit this lady and left. I would have stopped. I turned myself in freely yesterday because they was going to my people's house so bad. You know, I have nothing to do with this. I have nothing to hide. I have nothing to hide. I have not done anything.
Is there anything else, Mr. McMorris?
That's all.
Thank you. Ms. Ites, you have the last say. If you have anything else you would like to say, ma'am.
Just to reiterate, Your Honor, that for the safety of everyone in Greenville, Mr. McMorris must remain behind bars. Thank you.
Thank you, Ms. Ites. The court turns its attention to the state. First Sergeant Smith, is there something you would like to say on behalf of the state, sir?
Yes, Your Honor, and the solicitor here is going to present just some of the facts of the case, but we certainly agree with the family as the South Carolina Highway Patrol that Mr. McMorris is certainly a flight risk and certainly a danger to the community, and the state requests a no bond, Your Honor.
Thank you so much, First Sergeant Smith. Solicitor Maroney, you
Yes,
have the
Your
floor and you have the last say, sir.
Your Honor, Brian Maroney, on behalf of the 13th Circuit Solicitor's Office. On June 6, 2021, at approximately 1:40 p.m., the victim, Carly Sukup, was traveling on the Swamp River Bike Trail and was waiting for the light to change in the pedestrian and crosswalk area. And as it changed and turned green for her and red for the oncoming traffic, she entered into the crosswalk. Tragically, as she entered that crosswalk, she was struck by the defendant, who was traveling in his 2009 Chevrolet pickup truck. He disregarded the red light and failed to render aid and fled the scene. The subsequent investigation that is ongoing by the South Carolina Highway Patrol has revealed the defendant was in fact driving the vehicle. With respect to the defendant's criminal history, it is extensive. A 2002 conviction for possession of crack cocaine, 2006 conviction for possession of crack cocaine, driving under suspension, resisting arrest. A 2007 failure to stop for blue lights. 2010 assault and battery, driving under suspension, third or greater. 2011 possession of marijuana. 2012 driving under suspension, third or greater. 2013 failure to stop for blue lights, second or greater. Driving under suspension, third or greater. Criminal domestic violence, first degree. 2014 failure to stop for blue light, second or greater. 2016 felony resisting arrest with assault and domestic violence, third degree. 2018 domestic violence, second degree, and possession of marijuana. A 2019 probation violation, and a 2020 driving under suspension. The defendant also has current pending charges in the 13th Circuit Solicitor's Office stemming from June 2021 from a habitual traffic offender arrest and unlawful carrying of a pistol. As you know, Your Honor, you're well aware the habitual offender charge carries up to 20 years incarceration, reckless homicide up to 10 years, the hit and run resulting in death up to 25 years, and the driving under suspension, third or greater, up to 90 days, making a total penalty possible of up to 55 years. For those reasons and the reasons relayed on behalf of the family, it is the state's position the defendant certainly is a danger to the community and poses an extreme flight risk based on the serious penalties that he's currently facing, and we respectfully request that bond be denied.
Thank you so very much, Solicitor. All right, Mr. McMorris, coming back to you once again with the charges at hand. You do have this one magistrate level charge, and it's this court's responsibility to set bond on that magistrate level charge of driving under suspension, third or above offense. The cash and surety bond on that will be $2,105. For the remainder of your charges, reckless homicide, hit and run involving a death, and habitual offender causing death, I agree with the family, I agree with the state, and I agree with the solicitor that bond will be denied today. The request has been granted. Do you have any questions, Mr. McMorris?
When will I be able to get a bond?
What you would have to do, you would either have to hire a private attorney or get you a public defender, and you can file for a motion for a bond to be set. Your case will have to go before a circuit court judge in order for him to consider, or her to consider, whether a bond would be set or not. Okay? Are there any other questions for me, Mr. McMorris?
No, ma'am.
Thank you so very much, sir. This concludes your bond arraignment. If I can get you to take a step over to the left, please. One more thing, Mr. McMorris. One more thing. I need you to take a step under the microphone. You do have a condition of bond. I'm sure you don't know the family members, but regardless of whether you know them or not, there is going to be a condition that you cannot have contact with the deceased family members directly or indirectly. Do you understand that?
Like I said, I have nothing to do with this, so I have nothing to say to them, because they, like I said, they bashing my name off my past record. You know how you know people don't change, but I'm leaving it as that. I got a lawyer. So.
Thank you. Bond court is adjourned.
Thank you, Your Honor.
You're welcome.
I'll do it.
Pull the pen down, and that's your paper.